Private competition law enforcement is at an interesting point at the moment. We're seeing a lot more private actions in the national courts, and there's also a European directive just about to be finalised, which will change things even more significantly in a number of member states.
As a group, we are involved in several cases across Europe. For example, we are involved in the escalators case in Germany, we are involved in the asphalt case in Sweden, and the insurance case in Spain. And also we are very active in London, Peter, isn't it?
Yes, that's right. The London courts are emerging as a particularly favourite jurisdiction for competition enforcement for various reasons. And we've been involved in claims involving LCD displays and a number of other products as well.
As a firm, we have been on both sides of the fence. We have represented and we represent claimants, but we also represent defendants. This means that we have a unique perspective in the sense that we have an overall picture when defending clients or when attacking on behalf of the clients.
That's right, and I think the other thing that makes us special is that the firm is very heavily focused on complex cross-border litigation. We've got the top patent litigators in Europe, and there are very many similarities between competition claims and patent litigation. They involve complex jurisdictional issues, assessing markets, assessing products, and so on.
Indeed, this has proven to be a very effective way to approach the market, the combination between outstanding litigation skills and competition or antitrust skills. We should make a distinction between the continent and the situation in the UK. Certainly for continental jurisdictions, some basic principles are going to be harmonized, and for example, one area where the directive is going to have a strong impact is the area of disclosure, something that it is quite common in the UK but not so common in continental Europe.
Yes, that's right. In English courts, there's already very extensive disclosure of evidence between the parties. And actually, that's one of the reasons why the English courts are popular for this kind of claim, so that you can get access to the evidence. So that won't change so much in the UK, but we will see changes on things like time limits and the way that claims are allocated and liability is divided up between the parties. That will change in the UK as well.
Without any doubt, once the directive is adopted, the number of claims in Europe will increase. Ironically, what we are witnessing is that the number of claims is already increasing even before the directive is adopted.